Madame la Présidente de la Cour suprême des Pays-Bas.
Madam President of the Dutch Supreme Court, President of the Court of Justice of the European Union, President of the General Court of the European Union, colleagues, ladies and gentlemen, President of, how do you say it in French? It's not the State Council. To all of you, dear colleagues, friends, ladies and gentlemen, we are very, very pleased to be able to welcome you here today to The Hague for the 29th edition of FIDE, the FIDE Congress. When we started organizing this Congress, we were far from thinking of what would happen or imagining what could have happened. After the difficulties that we had of the financial crisis, the refugee crisis and Brexit, we wanted to move forward. And then came the pandemic. There seemed to be a real black swan. And yet here we are now. FIDE 2020 turned into FIDE 2021. A year and a half later, we are in the fortunate position of being able to meet in person, to be able to discuss our ideas and make contact with one another. The support and the encouragement along the way has been very dear to us all. Our general rapporteurs, our speakers, our young FIDE, our European lawyers, our media team from EU Law Live, and our sponsors, and in particular you have all stood by our sides.
On behalf of FIDE and the Dutch Association for European Law, I finally have the great privilege to declare open the 29th FIDE Congress in The Hague. Twice before did FIDE convene in The Hague, in 1963 and in 1984. The impact of FIDE on the development of European law has been well documented. From the outside, FIDE formed a unique transnational network bringing together key actors who stood at the basis of the new legal order and shaped European law as a discipline in its own right. The Court's constitutional understanding of European law was discussed and found broad support at FIDE's early conferences in The Hague in 1963 and in Paris in 1965. In the early 1960s, European law had yet to achieve its full potential. In 1984, FIDE discussed Europe and the media and the principle of equal treatment in economic law. Few of the participants then would have been able to predict the way in which the European legal order has matured, the degree of integration between the peoples of Europe, or the fact that today virtually all aspects of our daily life remains untouched by EU law. Just to mention one, the digital economy, that will also be on our agenda the coming days. The continuous development of EU law entails that our work is never finished, as new questions arise that need to be discussed and answered. The challenges the European Union face are huge and imminent. It therefore remains important to bring together European lawyers from all member states to listen, discuss, and understand EU law. European cooperation is not just an option, it's a necessity. Yet, this cooperation can only function on the basis of mutual trust, on the understanding that all members of the Union adhere to the same core values. And we all know that these concepts are not just of academic interest. Recent challenges to the rule of law, mutual trust, and the primacy of EU law have a significant impact on the actual functioning of our cooperation within the Union. Primacy of EU law does not only concern the relationship between one member state and the Commission or the EU. It is three or even multidimensional, affecting a member state, the EU, and the other member states. The lack of primacy of EU law, which is common to all member states, may compromise the principle of equality of the member states before the law. But at the same time, we also witness that the EU is a system that functions remarkably well. Every day, so many representatives of the member states and of the EU institutions come together to decide upon a great variety of issues, searching for and agreeing to compromises. And we all know that these compromises are never perfect, yet they are essential. I firmly believe that the European Union can and should be the framework to flourish and enhance cooperation between the European citizens and member states, strengthen free trade, free movement of persons, solidarity, and mutual trust, and provide for a sustainable, healthy environment. And these past 1.5 years has shown us that the Europeans are connected to the world and to each other. The initial reaction to the pandemic may have been a turn to national measures and national solutions. We all recall the attempt to close internal borders. And yet, the Union also provided to have its value, with a common approach to the approval of the vaccines and the EU coronavirus recovery plan. Once more, a crisis has given a new impetus to European integration. Ladies and gentlemen, our initial program has proven resilient and topical. Fresh challenges to the primacy of EU law, the importance of personal data for security and health, and new legislation regulating big tech. These are just a few developments that will take center stage in the coming days. And our panel discussions on the future of Europe and the safeguarding of the European values remain equally relevant. My hope for present and future members of the FIDE is to continue the debate and inspire new generations to actively participate in the debate on the future of the EU and the role of its legal framework. I am grateful that today we have in our midst all generations. Let me specifically mention a well-respected representative of the first generation of European lawyers and FIDE participants, Laurens Jan Brinkhorst, sitting here on the second row. He was here at FIDE in the Ridderzaal, where we were last night in 1962 and in 1984, and he's here today. Present as well are many young European lawyers, and we are proud to continue and expand on the recent tradition of organizing a young FIDE program in cooperation with the Europa Institute of Leiden Law School. After our first event in Estoril, the young European lawyers will again organize an event later this evening, where they can meet in an informal setting. So let me also mention the students in their blue sweaters with FIDE logo assisting the FIDE team. There too are European law students from Leiden University. And before passing the floor to the next speakers, I would like to thank and congratulate all those who have contributed to the organization of the Congress. In particular, I should like to express our special gratitude to the Court of Justice of the European Union, the City of The Hague, the Ministry of Foreign Affairs and the Ministry of Economic Affairs and Climate Policy, Leiden Law School and its Europa Institute. And finally, I should like to thank the FIDE 21 team. Let me mention, they're standing all over the place, I think, but you will meet them absolutely this day. Let me mention Marlies Noord, Herman van Harte, Jorrit Rijpma, Marleen Botman, Clara van Dam, and Carina van Os, our student officer from Leiden Law School, who joined us recently and was of invaluable help. Without their work and support, we would not be here today. I also want to thank FIDE's Secretary General, Charlotte Schillemans, and Treasurer Armin Kuivers for their excellent work for FIDE. There are many members of the Dutch Association for European Law who have put in valuable effort and work and inspired the FIDE team to make this Congress happen.
I'm looking forward to interesting and productive debates, and I'm quite sure that this Congress will be very successful. The fact that we are able to be here today discussing the State of the Union and its legal order here today in person, with one another, rather than being behind our screens, shows that we already are successful.
I wish you excellent, fruitful, and inspiring days. Now, the program indicates that we have a short intermezzo, a poem read by Hanneke van Eyck. Hanneke is lecturer and researcher at Utrecht University. She's one of the Dutch rapporteurs of Topic 1, National Courts and the Enforcement of EU Law, and expert on EU citizenship, fundamental rights and migration. But she's also an award-winning poet. She published 3 collections of poetry, and she's a well-known performer on literary festivals in the Netherlands and abroad. And at this moment, she's the poet of the city of Utrecht. Hanneke, can I invite you to come forward and read your poem, Europa rijmt en schuurt.
Good morning. Europa rijmt en schuurt. Europe has erased its borders. You can still see its sketch lines floodlit, its fields stringing together, its roads linking hands. It stands for language, for definitions, for regulation, for ambitions. Europe rhymes. It grades, it sings, and it growls. There's an army of officials. It has erected its institutions in concrete and glass dolls' houses. Europe is a hive of peace. It is a deed. In its villages live carpenters, photographers, and gypsies. In its cities, there's probably always someone waiting for love, tending a piece of land, learning to write or ride a bike. Its laws are as finely meshed as the first spring light on a sandy path in the wood. Europe is ports full of ships, nets of fish, plastic soup, and lands that fold their hands together in a pact, forming a sluice, a fold, a fort. Europe grades and it crawls, it rhymes and it sings. And if you ask me where does it begin, I will take you with me to Europe's navel. I will tell you the story of the nobleman's son, the story of the king of Pontiebraad. Here lies the birth of a masterpiece, an artistic structure. Honeycomb on honeycomb, honeycomb on honeycomb, honeycomb on honeycomb, honeycomb on honeycomb. Thank you very much.
It is an honor to introduce the President of the Supreme Court of the Netherlands. President De Groot is a well-represented member of the judiciary in the Netherlands since 1990, and she is President of the Supreme Court since November 2020. She has always valued the significance of judicial dialogue between the national and European courts as a meaningful instrument in the effective application and protection of European law. And she attaches great importance to the core values we all hold in common. Please, may I invite you.
Merci.
Thank you. Madam President of FIDE, ladies and gentlemen, colleagues, dear European friends, I'm extraordinarily pleased to see you all here in The Hague this morning.
Gentlemen, I will continue in English. It is an honor and a pleasure that I may speak to you on this opening ceremony of the 2021 FIDE Congress in the Netherlands. At FIDE, professionals within the world of European law unite to discuss the state of EU law on both European and national level, and as you saw before this morning, to feel Europe. For the Hoge Raad, working with EU law is daily practice. In my introduction, I would like to share some observations about the role of courts in dispute resolution and the development of EU law. And I will do this from my own perspective as a judge and as an academic with interest in dispute resolution. The Hoge Raad is the Supreme Court of the Netherlands for civil, criminal and tax cases and for some specialized administrative cases. And it is a court of cassation. The Hoge Raad reviews whether the previous court interpreted the law correctly, followed the right procedure, and sufficiently substantiated its judgment. The Hoge Raad provides judgments in individual cases within the judicial space of the wider dispute resolution system in the Netherlands and in Europe. The tasks of the Hoge Raad go beyond the particularities of the individual court case. The law distinguishes three different tasks. The Hoge Raad is expected to promote legal unity, to further the development of the law, and to safeguard legal protection of the people. The idea is that judgments given with an eye not only on the individual case, but also on these core tasks, encourage legal certainty in society, a vital aspect of the rule of law. I learned at the Hoge Raad that it requires a sort of judicial group sensitivity to assess which case might be suitable for which steps in contributing to legal unity and the development of the law, or in filling gaps in the legal protection of the people. This sensitivity is part of the respect for the division of powers between the legislature, executive and judiciary. But in particular, the sensitivity supports the Hoge Raad to take care of two main features of the case law of a court. One feature is that the outcome of a case must make sense in light of the facts of that case. Another feature is that the effectiveness of the law must be guaranteed in the living situation of citizens. The contribution to the legal system by judgments of national and international courts remains part of dispute resolution between citizens, companies, and organs of the state. Thus, for a court, an individual case functions both as an incentive and a restraint to seek for the appropriate contribution to the development of the law. The case-to-case approach of a court enables judges to seek for an interpretation or application of the law that suits the current case and leaves enough space for dispute resolution in forthcoming cases. The custom to deal with cases from the combined perspectives of dispute resolution and the three core tasks in the law system is also prevalent while working with EU law. In cases with an EU law dimension, I perceive a third perspective in the daily practice of the Hoge Raad. This is the principle of loyal cooperation with the Court of Justice of the European Union. I will provide you with some examples of the way the Hoge Raad gives effect to the principle of loyal cooperation in requests for preliminary ruling and generally in its dialogue with the Court of Justice in judgments. But before that, as an introduction to these examples, I will speak about the duty of national last instance courts to ask for a preliminary ruling. At the FIDE Congress, it needs neither explanation nor emphasis that EU law directly affects the national legal order. The Hoge Raad is one of the larger questioners to the Court of Justice. If a decision on a question concerning an interpretation of EU law is necessary to enable the Hoge Raad to give judgment, the Hoge Raad will, as a national last instance court, bring the matter before the Court of Justice on the basis of Article 267 of the Treaty on the Functioning of the European Union. The Court of Justice reasserted in its recent judgment in the case of Consorzio Italian Management and Catania Multiservizi the criteria identified in its judgment in Sylphid exactly 39 years before. for the exception under which a last instance national court does not need to ask the Court of Justice for a preliminary ruling. As an academic, I read with great interest the opinion of Advocate General Bobek to the Consortio case and his elaborated proposal for a new standard instead of the Sylvit criteria. As a judge, I was not surprised about the choice of the Court of Justice not to follow this proposal. In its judgment, the Court of Justice called Article 267, and I quote, "the keystone of the judicial system established by the treaties, setting up a dialogue between one court and another, specifically between the Court of Justice and the courts of the member states, having the object of securing uniform interpretation of EU law, thereby serving to ensure its consistency, its full effect, and its autonomy, as well as ultimately the particular nature of the law established by the treaties." Unquote. The proposal of the Advocate General was to relocate this keystone by creating another balance in the functioning of Article 267, in which the development of EU law by courts is given priority over the intertwined judicial tasks of dispute resolution and the development of EU law. In his proposal, I appreciate the recognition of difficulties of last instance national courts with identifying whether a question of EU law falls within the scope of a duty to ask for a preliminary ruling. But I doubt if such difficulties are, in light of Article 267, to be considered a legitimate reason to overrule the part of Sylvit in which the duty to refer was made subject to conditions of the specific case. Article 267 integrates the interpretation of EU law by the Court of Justice in the national dispute resolution systems of the member states. Therefore, the assessment whether the answer to a question of EU law is necessary to enable a national court to give judgment cannot be dominated by the perspective of the development of EU law. The Advocate General suggests that national courts will only be obliged to refer if 3 cumulative conditions are met. These are, in the words of the Advocate General, that a case raises 1, a general issue of interpretation of EU law, 2, to which there is objectively more than one reasonably possible interpretation, and 3, for which the answer cannot be inferred from the existing case law of the Court of Justice. I doubt whether the effectiveness and equivalence of EU law for citizens would improve if national courts would be able to refrain from asking questions in all cases that do not fall within the scope of these 3 general conditions. The role of courts within the rule of law is intrinsically linked to the need for a type of legal certainty that is developed by deciding on the merits of the case, with judicial sensitivity for the incentives and restraints in a specific case to contribute to the development of the law. Now let us have a closer look at the sometimes difficult task of courts to identify whether a question of EU law in a case should be referred for a preliminary ruling. As I said, I would like to provide you with some examples of Hoge Raad judgments. These examples show different aspects of the way the Hoge Raad gives effect to the principle of loyal cooperation in requests for preliminary ruling and generally in its dialogue with the Court of Justice. In the Consortio case, an Italian court had to deal with a party bringing forward questions of EU law twice. The Court of Justice highlighted in its judgment the aspect that the system of direct cooperation between the Court of Justice and national courts is completely independent of any initiative by the parties. This aspect was explicitly mentioned by the Hoge Raad in 2018 in a judgment about state liability in which it rejected the complaint of a party according to which the Hoge Raad previously unlawfully failed to ask the Court of Justice for a preliminary ruling. As to whether different language versions of a provision influence the decision to ask for a preliminary ruling, The Court of Justice recognized in the consortial judgment that a national judge cannot be required to examine each of the language versions of the provision in question. It, however, advises national courts to bear in mind those divergences between the various language versions of that provision of which it is aware, in particular when these divergences are set out by the parties and are verified. This has been common practice at the Hoge Raad. Sometimes English, French, and German versions are explicitly mentioned in judgments of the Hoge Raad to identify or even clarify doubts about the meaning of a Dutch translation or implementation of an EU law provision. Sometimes this comparison gives reason to ask for a preliminary ruling, sometimes to a final judgment of the Hoge Raad without a request for preliminary ruling. The Court of Justice added in the consortial judgment a duty for a last instance national court to provide the reasons for refraining from making a reference on the basis of the reasserted Sylphid criteria. With regard to giving reasons, I would like to mention that it is not uncommon for the Hoge Raad to do the opposite, under the principle of loyal cooperation, to demonstrate the need for a preliminary ruling by giving reasons for the perceived absence of an acte clair or an acte éclairé. The Court of Justice mentioned in its consortial judgment that a last instance national court can even be obliged to make a reference for a preliminary ruling in a case in which the Court of Justice already answered questions. A similar situation arose in the Franzen case, although not at the same court. The dispute concerned the social security position of cross-border workers. Initially, in 2013, the Dutch Appeal Court requested for a preliminary ruling. The Court of Justice did not answer one of the questions, probably because of a mistake in the understanding of national law. Later, the Hoge Raad had to deal with this case in the cassation procedure. The Hoge Raad stuck faithfully to the Sylphid exceptions. If these are not met, there is still uncertainty on a particular part of EU law, and follow-up questions should be asked. In 2018, the Hoge Raad decided to ask additional questions. And in the request to the Court of Justice, the Hoge Raad further explained national social security law. The second time around, the Court of Justice provided clarity on the matter. A recurring theme in judgments of the Hoge Raad is the commitment to contribute to the development of EU law. This is not just because national law prescribes that one of the three core tasks of the Hoge Raad is to contribute to the development of the law, or because Article 267 demands a judicial dialogue. It also relates to the role of the Hoge Raad as a substantial stakeholder on the rule of law in the Netherlands. This role stands in a wider picture in the context of EU law. This is especially relevant with regard to requests for preliminary ruling that relate to fundamental rights. One might think of questions on procedural law, such as various references in 2013 in customs cases on the interpretation of the principle of respect for the rights of the defense. Nevertheless, Dutch first instance courts, courts of appeal, administrative courts may just as much contribute to the debate on fundamental rights. This contribution may, for instance, be found in references for preliminary ruling on consumer protection. In the wider European picture, the Hoge Raad is hence a link in a judicial discourse that goes beyond the particularities of the individual court case. By a loyal practice of submitting references for preliminary ruling, the Hoge Raad aims to hold a constructive dialogue. In this dialogue, the Hoge Raad speaks directly to the Court of Justice and national courts, and indirectly to numerous other national courts in the European Union. It also listens closely to the European Court of Human Rights. This wider conversation enables courts to resolve disputes and at the same time contribute to the development of EU law. The dialogue is principally based on mutual trust in the Court of Justice, national courts, and other institutions in the three powers of state. In such a dialogue, it should also be a possibility to openly discuss whether legal or moral borders have been crossed without creating a conflict. The confidence amongst the judiciary and between the judiciary and other state institutions can in this context be viewed as a prerequisite for the confidence of EU citizens to have faith in the judiciary, in parliament, the government, both on a national and EU level. These remarks bring me to the end of this opening speech. I wish you an interesting Congress with rich discussions and lots of opportunities to connect in person. Thank you for your attention.
Thank you so much, President de Groot, for these thoughts on the recent consortium judgment, or SILFID II, if I may, and the difficult task of national courts to identify whether a question of EU law should be referred for preliminary ruling. Dear participants, dear colleagues, it's a long-standing and good tradition of FIDE to invite the President of the Court to speak to the community of EU law specialists, academics, judges, and practitioners of the member states. It's an honor, President Leynaerts, to invite you this morning to share with us your thoughts on the constitutional relationship between legal orders and courts within the European Union.
Dank u wel, mevrouw de voorzitter.
Thank you, Madam Chair. Madam President of the Supreme Court of the Netherlands, representative of the Council of State, Excellencies, dear colleagues, ladies and gentlemen.
It is a great honor and a pleasure to address you at the opening ceremony of this 29th FIDE Congress. And I'm particularly pleased to be here in such eminent company. I'm very grateful to President Wissels in particular and to all the other organizers of FIDE for having made this event happen in spite of all the difficulties that they have faced. I would also like to thank our court interpreters for being here, since without them, this Congress would not be possible, at least not in the same conditions. FIDE is a real success story. It provides a unique forum for bringing together practitioners, judges, and academics from all over Europe and beyond to discuss EU law. We have all looked forward to this year's Congress with particular anticipation, given that it had to be postponed due to the unprecedented COVID-19 pandemic. So I'm glad that we are all here physically present to discuss where EU law currently stands and what lies ahead. Our host city, The Hague, with its renowned judicial and legal traditions and institutions, provides the perfect venue for our discussions in the coming days. I would like to share with you today some thoughts concerning the role of the Court of Justice of the European Union and the position of EU law in general in light of the challenges that we currently face. The authority of the Court of Justice has been challenged in various member states, as has the primacy of EU law, not only by politicians and the press, but also before and even by national courts, including certain constitutional courts. This is an extremely serious situation, and it leaves the Union at a constitutional crossroads. I believe it is no exaggeration to say that its foundation as a union based on the rule of law are under threat, and that the very survival of the European project in its current form is at stake. That being so, I would like us for a moment to take a step back and to remind ourselves what the role of the courts in a democratic society, and more particularly in a union such as ours, is. As guardians of the rule of law, courts guarantee that both public authorities and private citizens respect the rules of the game. When required, they must uphold the rights of the few against the will of the many, even if that means delivering unpopular rulings. Courts must deliver their judgments without fear nor favor. Formally, the power of courts is grounded in a basic text, be it a constitution or a treaty. However, it is ultimately a society's commitment to the rule of law, democracy, and fundamental rights that gives force to that document, and thus to judicial decisions. Without respect for those values, a constitution or a treaty is no more than a piece of paper. Therefore, individuals must be convinced and must constantly be reminded that in order for them to enjoy liberty and justice, judicial decisions must be respected, in particular by the losing party. It is therefore to be welcomed when government officials state publicly that although they may not agree with the outcome of a particular case, it is their duty to respect the ruling and to enforce it. By contrast, when public officials state that courts are biased because they did not rule in their favor, when they criticize judges personally, or fail to react when the press call them enemies of the people, they ultimately undermine the rule of law. The same damaging consequences may ensue when courts themselves no longer respect each other and replace dialogue with open confrontation. That is particularly true in the EU, whose legal order is based on cooperation between the Court of Justice and national courts, as well as amongst national courts themselves. In order for that cooperative system to operate properly, both the Court of Justice and national courts must respect the division of jurisdiction laid down in the treaties. Like any legal system, the Union's legal order can only function if it is clear who has the last word in declaring what the law is. Thus, in accordance with Article 19 of the Treaty on European Union, as well as the requirements of uniformity and equality before the law, the Court of Justice must have the last word in saying what EU law is, just as national constitutional courts have the last word when interpreting their own constitutions. Moreover, the primacy of EU law, as interpreted by the Court of Justice, must be respected wherever it applies, since in the absence of uniform application of Union law, that law could no longer fulfill its unifying role as the law common to the Member States. It is also important to emphasize in this context that, as the Court of Justice made clear in the Whiteman case, membership of the European Union is voluntary. It is based on a democratic and sovereign choice made by each member state to join the Union and to accept the rights and obligations inherent in membership. Member state sovereignty is pooled, not relinquished. While I sincerely hope that no member state will ever again feel the need to exercise its rights under Article 50 of the Treaty on European Union, the fact that those rights exist reinforces the legitimacy of the EU and of EU law. For as long as a member state remains in union with its European partners under the EU treaties, all of its public authorities, including the highest courts, must respect the primacy of the law created by those treaties. as interpreted by the Court of Justice. Failure to do so undermines the equality of member states under union law and contradicts the democratic and sovereign choice made by the member state in question under its own constitutional law to join the union and to remain within it. European integration through the rule of law took 70 years to build. The Court of Justice is not the new kid on the block. The treaties may have been amended on several occasions, but the Court of Justice and the principles governing its jurisdiction are as old as the first post-war constitutional courts established in Europe. The Court of Justice has incorporated many constitutional traditions common to the member states into the constitutional fabric of the EU, thereby ensuring that EU law and national constitutional laws are deeply intertwined. Moreover, in recent years, the Court of Justice itself has been called upon to deal with a considerable number of cases, some of which are still pending, that relate directly to those common traditions, in particular the rule of law and solidarity at union level. The Court of Justice and the constitutional courts of the member states should be natural allies, not adversaries, in this context. It is also important to stress that, in spite of the difficulties to which I have just alluded, the work of the Court of Justice in dealing with the cases that come before it, and in particular with the references for a preliminary ruling that it receives from member state courts, continues smoothly and serenely, as President de Groot has also recently illustrated, referring to the case of the Hoge Raad der Nederlanden. Over the past 5 years, the Court of Justice received a total of 2,768 such references. That number, which has continued to rise unabated, except for a small drop in 2020 at the height of the COVID-19 pandemic, reflects the highly successful cooperation that continues to take place between the vast majority of member state courts and the Court of Justice within the framework of the preliminary ruling mechanism. Those references reflect many of the societal issues with which the member states are confronted, including questions relating to the pandemic itself. That is unsurprising, given how deeply embedded union law has become within national legal systems. Moreover, national courts are also the common law courts of the EU, called upon to apply union law as the law of the land, just like national law. It is true, and indeed it could and should not be otherwise, that most cases raising questions of EU law are dealt with directly by national courts without any need for the Court of Justice to be involved by means of the preliminary ruling mechanism. National courts thus play an indispensable role in guaranteeing the faithful and uniform application of EU law. That said, today's challenges concern not only compliance with judgments of the Court of Justice, but also access to the preliminary ruling procedure. It follows from Article 267 TFEU that a preliminary ruling mechanism is open to any court or tribunal of a member state. In applying that criterion, the Court of Justice takes account of a number of factors, such as whether the body is established by law, whether it is permanent, whether its jurisdiction is compulsory, whether its procedure is inter partes, whether it applies rules of law, and whether it is independent. Thus, in the Miasto-Wovic judgment of 2020, the Court of Justice had to make it clear that national judges must not be exposed to disciplinary proceedings or measures for having submitted a reference to the Court of Justice. Were it otherwise, judges might be deterred from choosing to exercise their discretion to submit a request for a preliminary ruling to the Court of Justice, or even to comply with their obligations to make such a reference. The Court will deliver a further judgment on this matter under the name IS, nothing to see with Islamic State, a judgment to be delivered in the month of November, this time not a Polish but a Hungarian case. Please read it in full in complement to my words of today. As regards the obligation to refer, just like President de Groot, I would like to draw your attention to this judgment of the 6th of October, and it was indeed 39 years to the day, or as I said to my colleagues, 13 renouvellements partiels further, because just like in 1982, the judgment had to be delivered on the 6th of October so as to be able to be signed by all the judges who left the court last 6th of October. This Consortio Italian management case, also called Cilfit 2, which of course has nothing to see with the actual Cilfit judgment, but it is indeed in line with that judgment, in which the court confirmed in substance its case law as to the three situations in which national courts of last instance are relieved of their obligation. The first one, as you know, is when the point raised of union law is simply not relevant to the outcome of the case. The second is the acte éclairé, and the third is the famous acte clair. And in complement to the perfect analysis of that judgment given by President de Groot, I would emphasize that the court here stated, as you said, that the mere fact that the national court in question has already submitted a reference for a preliminary ruling in the same proceedings does not, all by itself, alter the obligation to refer. The court also recalled that the national court of last instance may refrain from making a reference if the correct interpretation of EU law is so obvious as to leave no scope for any reasonable doubt. That's the restatement of Cilfit 1. However, before concluding that there is no such doubt, the National Court of Last Instance must be convinced that the matter would be equally obvious to the other courts of last instance of the member states and to the Court of Justice. And I draw your attention, in complement to what you said, to this point. It is the network of courts of last instance. This addition of last instance is not by accident. It's absolutely on purpose. So meaning that if a Supreme Court, an apex court, as often said, whether it be a constitutional court, a Supreme Administrative Court, or a Supreme Judicial Court, is made aware of the fact that apex courts in other member states have ruled in a way which is not in conformity with what they are intending to do, that all by itself triggers reasonable doubt automatically. If it's lower courts of the same or of other member states, there the court went on and said that the last instance court, seeing that there is divergent case law of lower courts of the same or of other member states, that should trigger their special attention to the matter, and they should be more rigorous in the assessment whether there is really no reasonable doubt left. And in any event, like President de Groot also stressed, and that is new in the Cilfit 2 case, the Supreme Court, sitting in last instance, must set out the reasons why the correct interpretation of the provision of union law in question does not give rise to reasonable doubt before deciding not to refer. Of course, like President de Groot says, there must also be reasons given when you do refer. That, by the way, and I supplement this, flows from Article 94 of the Rules of Procedure of the Court of Justice, where it is said that the referring court, all the referring courts, must set out the reasons why they came to doubt on the correct interpretation of a rule or principle of union law. On the substantive level, although union law now has some impact on almost every field of human activity and must prevail wherever it is applicable, the Court of Justice fully recognizes that the limits on the scope of EU law must be respected in accordance with the principle of conferral. To give one recent example, the Court of Justice held in June 2020 in the TUV Rijnland case that EU law, as it currently stands, does not apply to territorial limits on civil liability insurance coverage. Moreover, even where EU law is applicable, there is room for diversity. In the Centraal Israëlitisch Consistorie van België case, the Court of Justice emphasized that the EU legislator had intended to confer a broad discretion on the member states in the context of the need to reconcile the protection of the welfare of animals and respect for the freedom to practice a religion. The Court of Justice thus concluded that in an evolving societal and legislative context, characterized by an increasing awareness of animal welfare, the Flemish legislature was entitled to adopt a decree requiring a reversible stunning procedure in the context of ritual animal slaughter. So the Flemish legislator could make animal welfare prevail, although in another member state, take an example, Germany or Austria, the freedom to practice a religion might outweigh the concern for animal welfare. Union law accommodates that diversity in line with its motto, United in Diversity. Similarly, regarding unequal treatment on grounds of religion, the court recalled in Wabe and Müllerhandel that when several fundamental rights and principles enshrined in the treaties are in issue, the necessary proportionality assessment is to be carried out in accordance with the need to reconcile the requirements of the protection of the various rights and principles at issue, striking a fair balance between them. It found that the EU legislature had not itself struck such a balance between the freedom of religion and the legitimate aims that may be invoked in order to justify a difference in treatment, but had rather left that balancing exercise to the member states and their courts. In the context of the proportionality analysis, the court moreover observed that since EU law allows for the adoption of national provisions that are more favorable as regards equal treatment, a member state may subject the justification of a difference in treatment indirectly based on religion or belief to higher standards of protection. Those higher standards may result from national provisions protecting freedom of thought, belief and religion as a value to which modern democratic societies attach particular importance. In practice, this means that wearing the Islamic headscarf, that is what the cases were about, will more easily be accepted in the constitutional balancing of conflicting fundamental rights in the German, Austrian tradition than in the French tradition, which is marked by laïcité. Both of these cases illustrate the respect paid by the Court of Justice to the national identity of the member states, as provided for in Article 4, paragraph 2 of the Treaty on European Union, and to the diversity that accompanies it. Where, however, EU law itself lays down exhaustively the rules to be applied to a particular issue, those rules, as interpreted by the Court of Justice, must prevail over national law. Thus, as was held recently in the Maltese Republika case, national identity may not serve to justify a departure from the values of the Union set out in Article 2 TEU. Indeed, all member states subscribed, when they joined the European Union, to the common values of respect for human dignity, freedom, democracy, equality, the rule of law, and human rights, including the rights of those belonging to minorities. As regards the rule of law, The Court of Justice has repeatedly been called upon to specify its content, especially in the context of the requirement of judicial independence, in the line of cases beginning with the Portuguese judge's case in 2018. The Court has consistently held that while the organization of justice in the Member States is a national competence, all national courts which may be called upon to rule on questions of EU law must provide sufficient guarantees of independence and impartiality. Thus, while the EU does not impose any particular model on the judicial systems of the Member States, it does lay down red lines. Respect for those red lines and for the rule of law in general is the foundation of mutual trust. The European project and the solidarity among member states that this project entails depends on that mutual trust. I leave you with a final thought. The Court of Justice has been entrusted by the member states with the task of deciding what the law is at EU level. The members and staff of the court work extremely hard and constantly strive to produce rulings that are accurate, correct in law, and just. I'm very proud of them. However, a US Supreme Court Justice, Robert H. Jackson, once famously observed that, I quote, "We are not final because we are infallible, but we are infallible only because we are final." Indeed, in all legal systems, jurisprudence ultimately rests on a final decision, the res judicata. That is why all subjects of EU law, including the member states, and in particular their courts, including their constitutional courts, must comply immediately and in full with judgments of the Court of Justice, thereby upholding the EU rule of law and the equality of member states before that law. Thank you.
Thank you so much, President Leynard, for this rich speech on the rule of law, the primacy of EU law, the Chill-Fit II criteria, and solidarity among member states. And building upon the FIDE tradition to invite the President of the Court, we are grateful and honored that President van der Woude of the General Court has accepted our invitation to share his views on the place of the General Court in the institutional framework of the Union. May I invite you to enlighten us.
Madame la Présidente de la conférence.
Madam President, members of the conference, and dear colleagues, it's a real pleasure for me to be here with you all today for the FIDE Congress.
In English. As President Leynard just explained, the court is in the middle of a legal tempest. This doesn't come as a total surprise. The cases which were just mentioned are at the heart of societal issues. They touch often the core of where member states lie. Dealing with questions of higher societal importance is not the only worry of the Court of Justice, if I may, Mr. President. It also has to face an ever-growing workload. Against this backdrop, one might be inclined to forget that the Court of Justice is not the only jurisdiction that must safeguard the rule of law, apart, of course, from the national courts, also represented here. In the context of Article 19, in the sphere of the Union, ensuring the rule of law is entrusted to two jurisdictions, the Court of Justice and the General Court. In the sphere of economic administrative law, The General Court fulfills this task by upholding the rights which the treaties grant to individuals, companies, public authorities and states in their dealings with EU institutions. This role is important for two reasons, at least two reasons. First, in a context in which the EU institutions must deal with rule of law problems in some member states, their own conduct must be irreproachable. There can be no double standards in the Union. Second, the cases brought before the General Court raise rule of law questions of their own. They are different, but not less problematic. In cases dealing with large players of the digital industry, for example, the General Court is regularly requested to define the limits of private power over society. In many respects, the threats to freedom and open society also originate from private sources. Unlike the Court of Justice, the General Court has benefited from a reform that significantly increased its resources. I refer in this respect to Regulation 2015-2422. I will say henceforth the regulation, that's easier. Once the transition foreseen by this regulation has been completed, the General Court will be in a position to take on additional responsibilities. It follows that there are two Union courts pursuing a common objective, with one court gradually coming to the limits of its capacity and another court having, say, capacity becoming available once the transitional phase foreseen by the regulation has been completed. So the question arises as to whether the tasks between the two jurisdictions composing the institution should be reviewed, and if so, when and how. Obviously, this is a complex matter that not only requires, say, the input of the two jurisdictions, but also the national courts. Indeed, any reshaping and reorganization of the Union's judicial architecture must take account of national courts that ensure effective judicial protection in the member states. Even if the Union legislators have the final say in redefining judicial powers, a judicial system that doesn't have the support of all its constituent parts is bound to fail. In other words, any future reform should be acceptable for the Court of Justice, the national courts, and the General Court. Or to use a Brussels expression, or Eurospeak, Article 19 of the Union Treaty relies on a trilogue juridictionnel. Redefining the work allocation between Union courts is not easy. It cannot be decided in a hurry, and there is no hurry at all. The system as it is works relatively well, despite criticism often from dubious sources. Even so, given the time needed for reflection and the complexity of the matter, I submit it is important that we launch the discussion as soon as possible. First, as regards the Court of Justice, my colleague, President Leenaerts, is much better placed than I to assess the workload of his jurisdiction. My understanding is, however, that it is gradually reaching its limits, with high-profile cases becoming increasingly complex. Second, as regards the General Court, I submit that soon we will be able to take on new responsibilities. So my speech will be about that. The first part will be, of course, about the General Court, when we will have finished the review process, and then I will say a few words about the possible reallocation of powers. So first, about the court itself. Since 2019, we have adopted a series of measures concerning the internal reorganization of the court. That's internal business. I will not bother you with that. I think the results are more important. Of course, it's too early days to claim, say, a success. Even so, there are clear indicators that the reform has produced its results. First, the length of proceedings has decreased considerably. Second, we refer more and more cases to formations which compose of 5 judges, and hopefully soon, say, the full court, giving more weight to the judgments. It should also be noted that the criticism in legal doctrine about the allegedly unbearable lightness of the General Court's judicial control has ceased altogether. And I'm now looking at some people here in the room and even people complaining that we do overdo it in some cases. Finally, the General Court has been in a position to gain specific expertise in dealing with complex issues in the economic, medical, and chemical sphere. These results not only reflect the possibly subjective opinion of the President of the General Court, but also the more critical view of the Court of Justice. I refer in this respect to the report foreseen in the regulation, which was delivered in December 2020. The assessment made in that report is on balance positive. Of course, there is room for improvement, and we work on it, and many of the recommendations which were foreseen in the report were already on our radar screen. The conclusions of the Council of Ministers on that report were less positive. It is perfectly normal that the legislator is entitled to have a return on the budgetary investment. However, I am concerned by the tone of the Council's conclusions, since they seem to reflect the intention for constant monitoring of the internal functioning of the General Court. At a certain point, the page of the reform must be turned. It cannot and should not justify ongoing oversight on judicial activities, especially not in the context of today's crisis on the rule of law. Now, as regards the way ahead, I'm convinced that the General Court will make the reform a success. We gradually achieving cruise speed. Of course, having had to deal with the corona crisis was not an easy affair, but we're getting there, and we're completing an internal set of measures which we hope to have finished in September 2022. Of course, there are still challenges. There are challenges in the organization itself. We have to improve the way we handle large groups of cases. For example, in the banking sector, we often have groups of cases of 100 cases or more. Complex antitrust cases, state aid matters, and individual banking cases which continue to increase in complexity. There are also external challenges, and I would like to mention one, which is the permanent instability of our court. Judges come and go. Of course, that's perfectly fine, but it creates a heavy burden on the organization of the jurisdiction. Reshuffling chambers, reorganizing portfolios doesn't do the court very well. Even so, I'm convinced that in September 2022 we will be ready to accept new responsibilities. This brings me to the second part of my speech. What kind of models should we be thinking of when we think about reallocating tasks? Of course, there are many models. I will just have two models which are at the extreme of a spectrum. On the one hand, say, the one extreme deals with a pragmatic approach to a reallocation of tasks. It consists in a certain sense of triggering the mechanism foreseen by Article 256 of the Functioning Treaty and transferring, say, some cases from the Court of Justice to the General Court on an ad hoc basis. In a certain sense, the Court of Justice would become a dispatch, cases would be sent there, and if a case is not, so say, sufficiently important to be dealt with by the Court of Justice, it would be transferred to the General Court. This extreme model is akin, in a certain sense, to what was made in the past since 1989, when the competencies of the General Court grew organically. Even if the General Court is today a full court, a full jurisdiction after the Treaty of Nice, there is no reason why this gradual incremental approach could not be duplicated in the future. Even so, there are limits to pragmatism, of course, and I think the limit is the acceptability of a system by national courts, the other party in the trilogue juridictionnel. It might be strange from their perspective that if they refer a case to the Court of Justice, that then the case is transferred to the General Court. Would there be something wrong with the question? Would it not be sufficiently important to be dealt with by the Court of Justice? Would it not undermine on the long term the credibility of the system itself? So that would be the inconvenient aspect of that extreme model. And the other side of the spectrum, one might have a conceptual model. One relies on a specific concept of what each court should do. But what is that role? What concept should prevail in the reallocation of tasks? If you read the treaties, that's not very helpful. You don't find any clear indication as to who should do what. If you look at the roles of the courts, it's not helpful either. The Court of Justice has many roles. It's a constitutional court, it's a council of state, it's a review court. Sometimes it even acts as a court of appeal. So that's not very helpful. If you look at the General Court, it has basically two functions. We are a court of first instance, sometimes a trial court with above us a review court. But in some matters of the law, we have de facto the final say. That's Article 58A of the statute, which foresees for a mechanism of prior authorization of appeals before the Court of Justice. In the areas involved, especially trademark law, the General Court basically deals with the issue. So combining and comparing roles is not a real criterion either. However, I expect, and I'm comforted in my thought after hearing President Leenaerts a few moments ago, that the Court of Justice will increasingly be a constitutional court. And if that assumption is correct, the question arises, should the court be more selective? If you take, for example, constitutional courts in the United States, in the UK, and in the member states, they rarely deliver more than 150 written judgments per year. There is a limit to what a court can do. I submit that we should use this constitutional role of the Court of Justice as a criterion. That's obviously easier said than done. For example, if you take a case like Van Gent en Loos, that looked at first sight on a simple customs classification case, but it turned out to be a constitutional case. So what avenues could we see to put this Court of Justice in a more constitutional role? I see two main ways. One is to relieve the Court of Justice from its review function. And we could extend, for example, the system of prior authorization of appeals to more areas of law. This could be done, for example, by inserting in secondary legislation appellate bodies comparable to boards of appeal in trademark cases, justifying some kind of quasi-judicial review before they come to the General Court. And only cases which would threaten unity, the development and the coherence of European law would be subject to appeal before the Court of Justice. Alternatively, and more categorically, one could envisage to have some kind of internal review mechanism within the General Court itself, comparable to what is done in the US with federal courts of appeal. Another avenue, of course, apart from relieving the court from its review function, is to trigger the mechanism of Article 256. But how do you do that? What are the criteria? I would submit that there are perhaps two criteria which we could use. First, it is the specific expertise of the General Court. We have developed over the years experience in competition law, the law governing the registration of various chemical and medical substances, or the supervision of banks, and of course, trademarks. The second factor is more institutional in nature and refers to situations in which it is hard to define the dividing line between the EU administration and national administrations. These situations often occur when these authorities act as a network, such as the ECN in the field of competition law, or the single supervisory mechanism in the banking sector. But we also see those phenomena, for example, when it comes to registration of substances, networks of authorities acting together. In many respects, the intertwining nature of the EU and national authorities create confusion as to where private and public authorities can seek judicial review. In such situations, the case law of the Court of Justice clearly states that preference should be given to review by the General Court. I refer, for example, to the Deggendorf, Berlusconi, and Georgs Marienhütte case. Even if this case law purports to give priority to direct appeals before the General Court under Article 263, it could serve as an indicator for the specific legal areas which could eventually be transferred to the General Court. Now let me conclude. Even if I'm a pragmatist by nature, my preference lies with a conceptual model. And I think the times ahead and the tempest in which we are, the Court of Justice would and should act more as a constitutional court, leaving other responsibilities for the General Court, which could be a court overseeing the activities of the institutions when they act directly or indirectly together with national administrations in the sphere of the Union. I thank you for your attention.
Thank you so much for this informative speech and rather bold suggestions for a future discussion on the institutional framework of the Union. To end this opening ceremony, we had planned a live keynote speech by Vice President of the European Commission, Frans Timmermans. 1.5 years ago, he happily agreed to come to The Hague in person, but unfortunately, he cannot make it today. The Vice President, who's leading the Commission's work on the European Green Deal, he has, of course, pressing obligations elsewhere in Glasgow. But we are really grateful that he found some time yesterday evening to go to the studios of the European Commission and report a speech, which we will now show on the screens.
Honourable representatives of the judiciary, ladies and gentlemen, dear friends, thank you so much for inviting me to speak to FIDE today. I would have loved to do this in person and meet you in person, but sadly, because of the obligations I have with now the COP conference taking place in Glasgow, I cannot attend your conference. But I'm really honoured that you have asked me to speak to you, to share a message with you. I'm honoured because I have been a great admirer of your work for many, many years, starting, of course, with the European Court of Justice, whose work I follow on a daily basis, and a court that has been leading in creating a judiciary space in Europe that protects nations, that protects individual citizens, and that protects the rule of law. Now, we're in the middle of an incredibly interesting time, but also a time of huge upheaval. I think this time is only comparable to the first industrial revolution in terms of its implications for our societies, for our industries, for our economy, and also for our institutions, because in any time of fundamental societal change, and we are living through times of fundamental societal change, tectonic changes are taking place across the world, not just because of the pandemic, not just because of the climate crisis, not just because of the threatening ecocide, also because of hugely changing geopolitical relations, and because we're again in an industrial revolution. All this together poses a huge challenge to humanity. And whenever humanity is challenged and humanity needs to adapt to new circumstances, existing institutions will be challenged. This applies to political institutions, state institutions, and it applies also, obviously, to the judiciary. That is something we see across the board in the world, in the Western world specifically, whether you look at the United States or you look at the European Union. And that in itself is not something we need to be concerned about. It's in times of great change, you either adapt to the change or you become superfluous. So we need to adapt to the world that's coming. But we also need to make sure that in adapting to the world that is coming, we stick to the values we share and the values we deem essential for the functioning of our society and for the liberties our individual citizens cherish. In this context, I believe the strengthening, the preservation first and foremost, but the strengthening also of the rule of law and the concept of the rule of law is of essential importance. And in a world that is expanding, in a world where activities no longer are limited within national boundaries, in a world where acting on a continental scale becomes ever more important, being able to also act in terms of the rule of law on a continental scale becomes more important. And there we are very fortunate as Europeans to have a European judicial space which is based on the rule of law, which is based on the preservation of the liberties we cherish collectively. Now, what we learned from the period of oppression and dictatorships in Western Europe before the Second and during the Second World War, in Eastern Europe even until 1989, what we learned from that is that if unchecked, power has the tendency to control everything. Now, what happened in dictatorships in Europe was what you could call state capture. That is a party or the state capturing all the elements of a society, all the institutions, and forcing them to act in the interest of one party or of one state, and thus destroying the division of powers and destroying the rule of law and creating rule by law. And I want to insist on this point because sometimes we tend to forget our past, and especially tend to forget the darkest parts of our past, and tend to believe that state capture is something that would never happen again. Now, I always say to my students when explaining this phenomenon that nothing done in Nazi Germany was unlawful. It was unlawful if you apply the rule of law, but it was not unlawful if you apply rule by law, because every condemnation by a Nazi judge, every act against minorities was based on a law, but it was rule by law and not rule of law. The principle of rule of law is therefore extremely important to protect the individual rights of citizens, to protect our collective liberties, and also to make a functioning of a society based on openness and based on the protection of the rights of those who are strong and the rights of those who are weak extremely important. And for that, the judiciary is essential. For that, an independent judiciary is essential. Now, in Europe, another dimension is added to that. The dimension where we have agreed on a continental scale between 27 member states that it's not the size of your country that determines whether you're right or wrong. It's not the power of your army or the power of your security forces that determines whether you're right or wrong. It's the law that determines whether you're right or wrong. Treaties negotiated, signed, ratified by all member states, sometimes even submitted to public votes in referenda. Those treaties are the basis of the laws that we all need to respect, regardless of whether we're big or we're small. And the interesting, new, unique element of the European legal order is that maintaining this is a responsibility of all. Checking whether this is maintained is the responsibility of every judge in a member state and the responsibility of European judges at the European level. So every national judge is also a European judge. The European judge is also a national judge. And the interplay between them, unfettered, undisturbed by interference from political parties, from the state or from other actors, is of the essence to protect the individual right of all European citizens. The uniqueness of this model needs to be cherished, needs to be also, I would say, propagated as a model for other parts of the world, other continents that need to come closer together. But especially in Europe, it needs to be protected by all of us, because it offers a unique possibility to make sure that every individual citizen knows that EU law will be applied on her or him in the same way, whether they live in the Netherlands or whether they live in Sweden or in Italy or in Poland or in Spain. And if there is doubt about that, a national judge will decide. If the national judge does not know for sure, that national judge can ask the European Court of Justice how to interpret this so that we have a uniform interpretation of EU law. If this system is not respected or is made a subject of a political discussion or of forms of compromise that would undermine the working of the system, then EU law ceases to be applied everywhere. Then everyone can give their own interpretation of EU law, and then at the end of the day, there will be no EU law left, and it will depend on the willingness or the unwillingness of national authorities whether a citizen is protected under EU law, yes or no. And this is something we need to avoid. This is something we need to fight for. And that is why I believe discussing the EU law, the nature of EU law, and the future development of EU law is of the essence. And that's why your Congress is so important. Now, once again, let me be very clear. Nobody is beyond reproach. Nobody is beyond the need for reform from time to time. Neither state institutions, nor the European Commission, nor judicial institutions in the member states. But if we lose track of what underpins our systems, which is an open society where the rights of individuals are protected in the same way across the European Union, where the rights also of other economic actors are protected in the same way across the European Union, if we lose that sight of that fundamental principle, then we lose the most valuable elements of our European legal system that was based on the never again of totalitarian systems, that is based on the enshrinement of the democratic rule of law that is the basis of European societies. I wish you very fruitful discussions, and I will be very happy to learn from the results of everything you have discussed today. Thank you.
Today is the first FIDE Congress since Brexit, and we are delighted that the United Kingdom Association for European Law remains a very respected and active member of FIDE, and we are honored that its president, Emeritus Professor Paul Craig, has accepted to give a presentation on EU-UK relationships titled Brexit 4 Legal Lessons. What would a FIDE Congress be without the presence of our British friends, and in particular without Paul Craig, whose textbook on EU law, together with De Burka, are legendary to all students of EU law, not just those from the UK. Professor Craig, the floor is yours.
Thank you very much indeed for inviting me to speak. It's a very great pleasure to be here at the 2021 FIDE conference in The Hague and to be given the opportunity to say these few words. I would like to begin by thanking FIDE for allowing the UK Association of European Law to retain an associate status within the organisation, notwithstanding Brexit. I'd also like to begin by paying tribute to my predecessor, Sir Alan Dashwood, who did such a sterling job as president of UCAL, more especially given that his tenure covered the difficult Brexit period. Finally, I would like to express my thanks to the other members of the UCAL committee, including our excellent administrator, who have been of such importance in ensuring the vitality of the organisation, as attested to by the steady stream of webinars and other events staged by UCAL. The vibrancy in this respect is reflected in our calendar for the remainder of this year. We've already had 3 webinars. We have 2 more webinars, one on the Comstroy judgment, the other more broadly on conflicts between national courts and the CJEU, which I should add was set up before the recent Polish decision and has become even more timely in the light of it. And then we round off the calendar year with an annual lecture by Lady Vivian Rose from the Supreme Court, who will speak on the really interesting issue as to the circumstances in which the Supreme Court will depart from retained EU law. This provides in itself a fitting link to the points that I would like to make in the remainder of the time I have available. And actually, it's going to be 2 reflections, or a reflection on law and a reflection on the Constitution, which I will address. And I begin by reflecting on law, and there are 2 aspects of law and Brexit that I wish to speak to. One is relating to law and complexity, and the other is relating to law and bargain and consent. In relation to law and complexity, let me say the following. There are, I think, very few people who would have realized the full legal complexity entailed by Brexit. That is unsurprising, given that it was a voyage on uncharted seas. There were and are three principal dimensions to this complexity. Legal issues relating to the withdrawal agreement, to the trade and cooperation agreement, and to the status of EU law within the UK in a post-Brexit world. I certainly don't have time to explore all of that complexity, but let me just give you a hint of the complexity flowing from the last of these, the status of EU law within the UK in a post-Brexit world. The UK brought the entirety of the EU acquis into UK law through the EU Withdrawal Act of 2018. That might seem very odd at first sight, given that the UK was actually leaving the EU. The rationale for that legislation is nonetheless readily apparent. The UK was a member of the EU from 1972 onwards, and many areas of life were regulated by EU law. Now, while in theory it might have been possible to reject all this regulatory material in the event of Brexit, that would have led to legal chaos. The EU rules regulated matters from product safety to creditworthiness of banks, from securities markets to intellectual property, and from the environment to consumer protection. There could not simply be a legal void in these areas, and pre-existing UK law would not often exist. That was the rationale for the 2018 legislation. The foundational premise is that of the entire EU legal acquis being converted into UK law. And then the idea was that Parliament could decide in two stages which measures to retain, which measures to amend, which measures to repeal. So stage one was to ensure that the EU rules within UK law were fit for purpose by the time we left. So, for example, if there was a reporting line to the Commission, then by the time we left, that had to be a reporting line to a UK agency, because otherwise it wouldn't make any sense. Then the idea was that in the fullness of time, at greater leisure, the UK Parliament could decide what to keep, what to retain, or what to repeal. But that idea, you bring the entire EU legal acquis, just think about it. I mean, that's a lot of stuff. I actually did, on the back of an envelope, a calculation. I worked out how many UK statutes we passed a year, primary legislation, which was about 40. And I worked out how many years' worth of primary legislation the bringing into the UK legal order of the EU acquis was. And it was about 582 years' worth, which was really quite a lot of years. But then that's just the beginning of the complexity, because what actually happens is that when you bring all this material in, you can't bring it in the same way because the material is different. So in effect, the cornerstone of the 2018 legislation rightly distinguishes between directives which were already part of the UK legal order, regulations which were directly applicable, and unless something was done to save them, would not be part of the the UK after Brexit, and then directly effective rights, which were treated separately yet again. Okay? But that in itself was still only the beginning of the complexity. The 2018 legislation then had to decide a plethora of other issues. And I see this for any country which hopefully does not wish to leave, but any country that does is going to face a real set of legal complexity issues. So then we had to decide what was the status of this material once we brought it into the UK legal order. Was it primary legislation? Was it secondary legislation? Was it sui generis? Really important issues. These mattered. Then we had to decide what was the relevant status of that material in relation to both pre-Brexit UK law and post-Brexit UK law. I could wax lyrical further, but I will not, given the exigencies of time. Let me pass on to the other legal issue that I have, which is really one of importance, and I say this with some embarrassment about my own country, which is legal obligation. We talked, and the previous speaker spoke eloquently about the importance of the rule of law from various dimensions. One of the most foundational elements of the rule of law is expressed in the idea of pacta sunt servanda. The UK signed up to a plethora of obligations in the withdrawal agreement, which included the Northern Ireland Protocol. It seems to me, in putting it in the most mildest fashion I can, deeply regrettable, to say the least, that there was a contemplation in the Internal Markets Bill with political equanimity, if I can put it that way, that we could brush aside some of these legal obligations or push them aside when we did not wish to honor them. Equally, much of the rhetoric now, political rhetoric, about the Northern Ireland Protocol is based on disingenuity about the legal provisions and about the political background leading to those legal provisions. No one who studied that area in any detail at all could be in any way left under the impression that the Northern Ireland Protocol was going to lead to a border in the Irish Sea, which is exactly what it's led to. That was there in black and white for everyone to read. And of course that's problematic, but it's a deal to which our government signed up because they wanted, in inverted commas, to get Brexit done. The idea that we should turn around now and, as it were, say, oh, we never really understood what we were signing up to, or this is really rather awkward now, we'd rather not comply with it, seems to me, in the most profound sense, offensive against the rule of law. Let me turn then to the second dimension, which is sovereignty and control. The considerations that informed Brexit were eclectic, including the desire to control borders, discontent with the workings of the EU, and sovereignty. It was, however, sovereignty that became the principal consideration that informed the UK's negotiating discourse on the trade and cooperation agreement. It played out in multiple ways, as exemplified most notably, albeit not exclusively, by the Prime Minister's pushback on the idea of a level playing field. The assumption, explicit and implicit, was that Brexit meant an accretion of sovereign power compared to the status quo ante. The thinking was cast in zero-sum terms. The EU had power over certain areas. Those areas would be repatriated to the UK, which would then take back control over its own destiny. The assumption was that what was repatriated would accrue to the UK Parliament. This would thereby increase its sovereignty and enhance democracy by allowing our elected representatives to signal their assent or rejection of the choices placed before them. That was what we were told. The reality was actually rather different in a number of respects. Firstly, it was different because Parliament exercised almost no control whatsoever by way of sovereign choice over the TCA itself. It did so in formal terms because it enacted the legislation required by a dualist country to bring the TCA into UK law in the form of the European Union Future Relations Act of 2020. There were, however, severe exigencies of time, about 36 hours to be precise, and actually most MPs really didn't spend those 36 hours labouring over the 1,246 pages of the TCA, and they wouldn't have understood them even if they had laboured over them. So the idea that this can be regarded as an accretion or a manifestation of parliamentary sovereignty is to beg a belief. Parliament also, secondly, exercises scant power over the subject matter dealt with by the TCA itself. The issues previously regulated by the EU in this area will henceforth be regulated through a series of bilateral treaties such as the TCA. And Parliament has scant involvement in any of the decisions taken pursuant to a TCA-type treaty or any other such bilateral treaty. That's readily apparent from the decision-making structure in the TCA itself. The operative decisions are made by the Partnership Council and a plethora of trade and specialised committees established pursuant to the TCA. There are broad powers to make binding decisions, and those binding decisions become operative legally in the UK without further ado. Parliament, in any manifestation, will not exercise control over these measures. Thirdly, in relation to the accretion, or not, of sovereign power by Parliament, the reality is that Brexit has massively increased the power of the executive at the expense of Parliament rather than Parliament as a sovereign body. That is manifest in a number of different ways. While the Brexit political rhetoric was repeatedly framed in terms of sovereign power and control, the political reality has been that the executive has taken much of this power. The complex Brexit legislation contains a very great number of instances where far-reaching powers are accorded to the ministers, with little by way of, parliamentary oversight. This is then reinforced by quaint, in inverted commas, techniques that we have mastered in the UK, whereby this accretion of executive power can be legitimated. None more so than the famously known Henry VIII clauses. Actually, it's a bit of an injustice to Henry VIII, because Henry VIII may have done all sorts of bad things, but he actually didn't quite do what is called a Henry VIII clause. But what happens under a Henry VIII clause is that what it does is it allows the executive to enact secondary legislation, a statutory instrument, delegated legislation, and through that statutory instrument they can amend or repeal any primary legislation. Okay? Now, the secondary legislation itself is subject to scant parliamentary oversight. So what you're doing is you're passing a piece of primary legislation. The primary legislation contains Henry VIII clause, and the Henry VIII clause allows the minister to propose and draft a statutory instrument which then repeals or amends primary legislation, with Parliament having little say. Now, these clauses have existed for some time. Their numerical incidence has increased enormously in a post-Brexit world. Every piece of UK Brexit legislation has a plethora of such clauses, and they have been used very readily by the executive. Very briefly, fourth and fifth way in which sovereignty has not really, in reality, accrued to the UK Parliament. Fourthly, the very idea that Brexit was required in order to enhance sovereign choice was, moreover, more than a little ironic in relation to the EU. It is true that the EU constrains choice. This is, however, the consequence of all forms of collective action. Individuals and states make choices. They can remain on their own and maximize their own autonomy. They can join clubs, treaties and the like, which perforce limit their sovereign choice in various ways. the trade-off being membership benefits combined with the increased power that flows from being within the club. The language of control, as applied to UK membership of the EU, did not, moreover, represent reality for a number of reasons. While in the EU, the UK played an active part in shaping the very nature of the EU as it developed over time, as exemplified by its role in single market initiatives and those concerning the AFSJ and financial services. The reality as well is that the EU disagreed with very little EU legislation when viewed in terms of volume over time. And moreover, the UK secured for itself over time every conceivable opt-out or differentiated form of integration that could possibly be hoped for. So this story that the UK was the poor put-upon state that was, as it were, under a yoke of control imposed upon it by some outsiders, made great sense if you were trying to campaign for the UK to leave the EU. It just made no sense in terms of legal and political reality. Finally and fifthly, the very idea in a post-Brexit world that there is some fundamental disjunction between control, which is what pertains while we remained in the EU, and free trade, which is the mantra thereafter, was equally misleading. I mean, language, think about it. Language is, we live by and through language, and language is inherently tendentious. The very words convey a sense of meaning or are employed in that fashion. The language of free trade was used in spades by the Brexiteers to say, here we are under EU control, now we've got the nirvana of a land of free trade. Free trade meaning freedom. I mean, this was a joke, but it wasn't a joke. It was really very serious. It was, in the sense of, it was played out time and again. But of course, anyone who understands free trade treaties will understand that free trade treaties do not entail freedom in that sense. When you sign up to a bilateral or trilateral free trade treaty, you are signing up to obligations, as is revealed massively by the very text of the TCA and any other bilateral or trilateral treaty. So this, as it were, false or fallacious contrast between freedom, which we're going to get outside the EU, and, as it were, control, which is what pervaded hitherto, was again one played fully by the Brexiteer lobby to tragic consequence. I'm very grateful for the time that you've taken and accorded to me, and I'm very grateful for the opportunity to be here, and I'm delighted to be taking part in this FIDE conference. Thank you very much indeed.
Professor Prick, it's always a pleasure to listen to your presentations. The Dutch Association for European Law has had the privilege of having you as a speaker on Brexit on 2 occasions before in Utrecht, and that was during the Brexit period. Thank you so much for sharing your thoughts on the legal complexities entailing by Brexit, the desire for sovereignty, control versus political reality, and legal reality. Dear friends and guests, we will now turn to the final part of this morning, the panel discussion, Fit for the Future, What Role for Europe at Home and in the World. European law cannot be considered in isolation. And to foster a more multidisciplinary law in context approach, we have asked European thinkers of other disciplines to come here and give their reflections on the future and the ways ahead. And I'm thrilled that Luc van Middelaar, Caroline de Gruyter, and George Papakonstantino have accepted our invitation to speak. They will be introduced by our moderator, Christa Tobler. And Christa Tobler is an active participant of FIDE congresses and a familiar face to many of you. After her LLM at European Community Law at Leiden University in 1994, if I'm right, Professor Tobler has remained loyal to Leiden University, and she continues to be active both professionally, both in Switzerland and in Leiden in the Netherlands. She's a professor of European law at Leiden University and in Basel. She has 2 research specializations, the legal equality and discrimination, both in economic and social law, and the complex legal relationships between Switzerland and the European Union, another very complex relationship indeed. Christa, I invite you to come over with the panel members and take over.
Welcome to all of you to our panel. It is my great pleasure to preside over this panel with the topic Fit for the Future, What Role for Europe at Home and in the World. When we had a pre-talk about this subject matter, it seemed to us that this was a real tall order. If you think about it, is there anything that doesn't fit this topic? Anything that keeps us busy in the European Union at the moment? Lots of things can fit into it. But when I heard the topic for the first time, I was reminded, in fact, of a book published by Leiden University 5 years ago with the title Fit for the Future, Reflections from Leiden on the Functioning of the European Union. The reason for writing this book and for publishing this book was the fact that the Netherlands at the time held the Council presidency. And the book wanted to reflect on what it means to hold this presidency at the situation that we had in the European Union at the time. I went back to the book and I looked into the foreword, and I saw that it spoke about the fact that instead of being in a constructive era, the European Union at that time was going through a series of unprecedented crises that threatens its very integrity. And the foreword mentioned 3 of those, namely the financial and economic crisis, and I think we all agree that we still feel the effects of that. Secondly, that the safeguarding of some of the most fundamental elements of European integration was at stake, and the book mentioned at the time free movement, thinking about the migration issue, that we still have, and we have the issue we heard much about this morning already, the rule of law. And the third issue is what we just heard about, namely at the time the referendum of the United Kingdom on British membership in the European Union. All of this is still with us. All the effects of that are still with us. As you heard, the idea of this panel, as developed by the organizers, is to hear the views of non-legal thinkers on the questions of where to go with the European Union at home and in the future. What should be the role of the European Union? And these more general reflections from a non-legal perspective should give us a broader outlook that will be our background and our context also for the more specific legal discussions to follow in our Congress. So I look very much forward to the discussion, and it's my pleasure to briefly introduce the 3 speakers to you, who afterwards will each of them give a brief, at the most 10-minute introductory statement. Then we will engage in a discussion, and if you wish, we can dedicate a last part of the panel to questions that you may have to our panel speakers. So you can already think about the issues that you may want to raise. I will introduce the speakers in the order of their introductory statements, beginning with Caroline de Gruyter. She is originally a linguist. She studied Dutch language, but she has since moved into political issues, legal issues, historical issues, many things. She is a Europe correspondent and columnist for the very, very respected Dutch newspaper NRC Handelsblad. currently based in Brussels, and she has covered European politics for the past 20 years, both from the bubble, in inverted commas, in Brussels and also from elsewhere in Europe. Her voice and expertise about Europe are well known in the Netherlands, and I learned this morning that she has a fan club also in Belgium, including the President of the Court of Justice. Caroline is also a columnist for Foreign Policy and the EU Observer, a member of the European Council on Foreign Relations. She was previously based in the Gaza Strip, Jerusalem, Brussels, Geneva, Vienna, and Oslo, so she has seen many places, and she has written a number of books, and the last of which I will mention a little bit later. So welcome very much to our panel. The second speaker then in our panel will be Professor Luc van Middelaar, Professor of Foundations and Practice of the European Union and its institutions. He is a historian and philosopher and political theorist by training. He has held a number of offices. He was most notably perhaps speechwriter and advisor of the first permanent president of the European Council, Mr. Van Rompuy. He was political secretary of the VVD party in the Dutch lower house, and he worked for the office of European Commissioner for the Internal Market, Frits Bolkestein. He is also a columnist for the Dutch newspaper NRC Handelsblad, and he publishes in other newspapers, including Die Zeit and Le Monde, and also Swiss ones, I may add. Welcome to the panel to Luc Middelaar. And our third speaker will be Professor George Papakonstantinou. He is Professor of International Political Economy and Director of Executive Education at the School of Transnational Governance of the European University Institute in Florence, Italy. He holds a PhD in economics, so you bring a new line in our discussions, and he has served as a senior economist at the OECD. He has also served in a number of policy advisory roles and in active politics as a member of the Greek Parliament and of the European Parliament. He has been finance minister for the Greek government, and from that position at the outset of the Eurozone crisis, he played a key role in the negotiation and implementation of Greece's first support program. Subsequently, he became Minister of Environment and Energy, and he pursued policies to advance Greece's sustainable growth agenda. Welcome also to our panel. You see, ladies and gentlemen, we have a highly interesting panel of non-legal speakers who will ponder this question that's before us: fit for the future, what role for Europe at home and in the world? And with this, I would like to turn to our first speaker. That is Caroline de Gruyter. All of our speakers have written well-noticed books. In her case, the one that I found possibly the most interesting is a best-selling book about a comparison of the Habsburg Empire with the European Union. And it has the catching title in the Netherlands language, Beter wordt het niet, what you can perhaps translate best as, "This is as good as it gets." A reality check for the European Union. I look forward very much to your introductory statement. Please, Caroline.
Thank you, Christa. Thanks for your kind introduction. Yes, I would like to go a little bit deeper into the main theme for this session, namely, what role for Europe at home and in the world? The gist of what I'm going to say is that Europe is an internal project, and it's not really proactive, nor at home, neither at home nor in the world, and it's mostly reactive. But it's getting sometimes rather good at it. Why is this the case? Because the internal and the external are incredibly related. They're always related for any state of entity, but even more so, I believe, for the European Union, because we are with 27. And we are with several institutions, and everybody needs to have a share the pie and ownership with the project and every decision. The EU is an internal project. It's meant, just like the Habsburg Empire, and that's what my book is also about, it is meant to keep the peace on the continent. This means that we have beautiful rules and laws that we are all bound to, but at the same time there is a political impetus that everybody needs to have ownership. This is the case in the EU, and it was also the case in the Habsburg Empire. There can be no winners and losers in Europe since 1945, or the early 50s rather. It was the essence then, no more war on the continent, stability on the continent, and it's still the case. So everything that happens, either from the inside or from the outside, upsets a certain kind of balance. Institutional balance, political balance, existing arrangements between all the member states. Everything that happens sort of creates fierce rounds of negotiations, always, because we are unprepared, or because it affects a set of arrangements that we already have and which need to be reviewed or reset even. From the inside, think of the euro crisis, and also think of the rule of law issue now with Poland. This sends us all into a frenzy of negotiations. Events from the outside that really need our response include migration or Russian cyber attacks, for instance. Each time something happens and we have to sit together and negotiate among ourselves. We are, in fact, always negotiating with ourselves. We are navel gazers. And whether you like it or not, this is the case. And we better accept it and make the best of it. This makes it very difficult for the European Union to plan ahead, to think ahead. We can all think ahead, but when you go to Estonia and ask them there what are the main challenges, the answer will be different from the answer you will get in Portugal or in Ireland. Plus, the European Union can only act when in most cases, when member states want it to act. And this is usually after they have tried themselves to solve a dilemma or a problem, and they don't manage. One great example, recent example, is vaccine procurement. First, they tried themselves, and then they realized, okay, some countries will get vaccines very fast and maybe cheaply because they're big. Others will perhaps get them 6 months later, and this will create incredible political tensions on the continent. So we'd better ask the Commission and do it for us, which happened. It was late, but I think it's a great example of a good action, European action. But again, the EU mostly reacts, including in the vaccine story. So it always takes time before something happens. All member states, they have their own traditions, their own wish lists, their own hang-ups. They come with it to Brussels, and whatever the issue on the table, they all have a different take on it. So it's always, what comes out is always some kind of a compromise, because everybody needs ownership. Otto von Habsburg, the son of the last Habsburg emperor, he once said, multinational states and entities cannot fight offensive wars. Why? Because they can never have all the noses in the same direction. This was true for the Habsburg Empire, and it's true for us these days. At most, we can fight a defensive war, probably. Otto von Habsburg again. For a multinational state, war with the neighbors means war with itself. And there you see how the internal story is linked to the external story. I was based in Geneva a couple of years ago, following discussions at the UN, negotiations at the UN. And it always struck me how the EU likes to act as a bloc, because if every member state does his own thing, they have no impact. So they try to come up with a common statement, a common position. But the negotiating among EU member states in the big chambers of the Palais des Nations in Geneva usually took longer than the negotiations with all the members of the United Nations. So, to round up, we have no alternative but to accept that we are always coming up with compromises that are not perfect, both at home and abroad. We have to muddle through exactly like the Habsburgers did. But they were good at it, and they kept going for 600 years. That's perhaps the good news. Yeah. Sometimes we do it successfully, like in the vaccine procurement, and sometimes it is we're not good at it. You know, it's a disaster. In the migration policy has hardly moved in 20 years. Vis-à-vis Belarus, I'm not sure anybody is happy with what we're doing. But we learn. When I started to cover EU affairs, there were four summits per year. And even those agendas, they were set far in advance. You know, one was on the economy, the other one was on foreign affairs issues. Now they're at it like sometimes 2-3 times a month, and sometimes even more often. We learn, and sometimes I'm even surprised how good we become at navigating through a world in which everything changes rapidly and everything demands a response from us. I think this is also because we are using Habsburg tricks. The Habsburg Empire was an interstitial power, just like the EU is an interstitial power, surrounded by rivals who don't want this interstitial power to collapse, because that will create a black hole and they can be pulled in it. But they want to weaken it. And this is what we are experiencing now. The Habsburgers never knew where the next attack would come from. It's the same with us, and we are never prepared, like they were never prepared. So we do what they are doing, muddling through, using delaying tactics. Sometimes, you know, a dictator dies and the story changes. Or somebody comes to our aid. Yes, I'm rounding up. We need allies, just like they did. So we make deals with maybe not too friendly powers, and we create buffers outside our external borders. Everything is a compromise. Nothing can be perfect in the EU, both at home and in the wider world. Thank you for your attention.
Thank you very much, Caroline. You have been emphasizing how the internal and the external are linked, how the EU is engaging in constant negotiations. You used the term muddling through, and you gave us the hopeful perspective that perhaps for 600 more years we will muddle through. Thank you so much. We will turn to our second introductory speak by Professor Luc Miedelaar, my esteemed Leigen colleague. Your latest book is entitled Pandemonium, and it's obviously about the COVID-19 crisis and what this has meant for the European Union and how the European Union has reacted to it. And you said in our pre-talk that you would use this example in order to address the topic of our panel. We look forward to what you have to tell us.
Thank you, Krista, dear colleagues. Yes, I thought it would be good to look at the European response to the pandemic, basically as an example of how our union fares at the moment of deep uncertainty and danger, something it has had to learn. And in a way, any crisis, be it in personal life or in political life, is a moment of truth, a test. You get to know your friends. Sometimes they become ex-friends. Sometimes you make new friends in a crisis. And the same is true for a political or legal order. And when we have all these dangers and risks coming our way in the decades or even centuries ahead, it is therefore can be revealing to look at how the EU has done during this most recent test, which is not yet behind us, but which has caused a little delay of this conference, but which we are, in a way, getting in the grips nevertheless. Now, I want to make 3 points. The first point is the remarkable contrast between very bleak and bitter scenes in Europe and at EU level at the moment of the outbreak of the COVID crisis, February, March 2010, and contrast that with the rather surprisingly robust response a mere 4 or 5 months later. Well, you all remember, because we all lived through these moments very intensely, either privately or professionally, but nevertheless, maybe just in 2 or 3 sentences. February 2020, these were the moments of national mask hoarding, the Commission being powerless to uphold the rules of the internal market. When Italy cried for help, asked for help to its neighbors, no help came, only from China 2 weeks later. Borders were closed, bitter fights soon erupted over a lack of solidarity in the financial front, etc., etc. And sure enough, within a matter of weeks, the first voices started to predict the end of the European Union. Some, let's say, not so friendly voices from the markets or from Moscow and Beijing, but also worried voices, including from the Pope Francis himself in Rome. But then, as said, within the space of 4 or 5 months, 2 far-reaching, almost revolutionary decisions. One, Caroline has already spoken about. This was June 2020, the decision to jointly purchase a vaccine, to mandate the Commission to buy the vaccine on behalf of 450 million EU citizens, which was very revolutionary, especially if you remember that at the outbreak, the language was more public health is not an EU competence. We're very sorry, this is a horrible crisis, but there's not so much we can do. 4 months later, there's a vaccine program. A second, maybe even more revolutionary decision was in the economic and financial sphere, the Corona Recovery Fund. And that is something I know George will say more about in a minute, but I will just want to highlight these 2 very strong responses. Now, so that leaves us with 2 questions for the remainder of the time I have with you. One is, so why this panic at the outbreak? Why the panic? And 2 is, why the speed of the response? Now, for the panic, it strikes me that it happens all the time. Whenever there is a crisis threatening some achievement of the EU, be it the currency or Schengen, people immediately also predict the very end of that achievement, the end of Schengen, the end of the euro. Now, some people have interests in that, and in the case of the euro, there were even financial interests, people betting against the euro. And well, I did some research for my Pandemonium book, also in the field of literature. So I read a great book by Daniel Defoe about the year of the plague in London, 1665. He draws on testimony by his uncle. And one of the stories he tells is, in London in those days, I mean, thousands of people were dying. It was a horrible plague, and people were locked up in their house, etc. But there were people also making fortunes, selling astrological brochures, predicting that the end of the world was nigh. So just before you were going to die from the plague, you could still buy the brochure and have the exact date. So there's something in these prophecies of doom which apparently appeal to human nature. But there's something else, and that links back to what Caroline just said. And that is that, in a way, in the EU, we need these existential threats to act. So it is not only these prophets of doom who not necessarily wish as well, but it is the governments, the political executive itself, which needs to create sometimes, or at least emphasize, certain threats to put those who are more reluctant to take action under pressure, etc. And in this respect, I may quote indeed Herman Van Rompuy. The time I worked for him as European Council President, he had to get 27 and 28 national leaders into line, and he always explained to his audiences that this was very difficult, and basically you had to wait until they all felt they were in front of the abyss, with their back against the wall, and then he added, for good measure, with a knife against their throats. And then the EU could act unanimously and find the compromise which was needed to get out. Now, obviously, that is a weakness. That's a weakness of the system, that you need this fear, but it has to do with the simple fact that the EU is a union and not a state. And I do think things can be improved. We need, clearly, the EU needs a better capacity to anticipate, but the ultimate conundrum is not so easy to solve. So that was about the panic. Why the panic? Remains the third question, third point, second question. Why the speed? What happened? Why was the EU able to react relatively quickly to the pandemic compared to, well, let's take the euro crisis, which George has also lived through intensely, where it took 2.5 years of deep uncertainty, market uncertainty, financial instability between late 2009 and the magic words of Mario Draghi and banking union decisions in the summer of 2012 to calm the situation, whereas here it was a matter of months, as I said. Well, one explanation is that the system has been made more robust as a response to that financial crisis. You could see it, the fact that there is now a European Stability Mechanism, ESM, which played a role. The European Central Bank has learned to act more quickly, as it did also in the pandemic. And we may hope that a new pandemic will also be responded to more convincingly early on. But here too, nevertheless, and that's my final observation, it was not just the fact that the EU system has strengthened its executive capacity to respond to a crisis in the financial field. In the pandemic, something new and what I found fascinating was happening. That is, I would call the emergence of a European public sphere more clearly than before. The fact is, what made political leaders act, not least the German Chancellor Merkel in Berlin, was a public outcry for help, a public call for help, which came from Italy first, from Spain, then from other places as well. And they said, or the call was, Europe has to do something. Now, Christa was not so clear what Europe this was, which institution, etc. But the crisis was felt by the public to be so big that Europe had to act. And that was what was done. And the new element there is that it was really also a call from one public opinion to another. I'll take one example. It was a fascinating example. Local Italian politicians bought ad space in the German newspaper Frankfurter Allgemeine Zeitung, March 2020, at the height of the crisis or the financial woes, basically making the plea for Corona bonds, or however you want to call them. I don't want to go into that debate. But it was a call from one public opinion to another saying, well, we share one space. What you decide in matter of vaccines or state aid also matters for us. And our public health is a matter of common concern, a res publica. To conclude, in this pandemic, EU has shown some unsuspected, maybe, resilience, drawn on previous capacity to learn. We see an emergent public sphere as well. But on the less bright side, we still have this need of panic to trigger these changes, and that is something to work on in order to be even more fit for the future, how long that will be. Thank you.
Thank you so much, Luc. You have told us that a crisis is always a moment of truth, and that in this particular crisis we have seen both the weaknesses of the European Union and its strength, actually. You mentioned at the end this European public sphere, this common area where we are in, and also the issue of Europe. The joint procurement agreement that you have mentioned is in fact something that goes beyond the European Union. I've looked into it also myself. We have other countries participating there, quite a few actually. So this shows that when we say Europe in this context, it's actually not only the European Union. It's always a delicate point for those of us who are not from inside the European Union, because Europe is obviously greater. So thank you very much for that. You have mentioned also the economic element, and this is where we turn to George, who is, as I said, an economist and has a vast experience practically and otherwise with the Euro crisis in particular. Your latest book is entitled Whatever It Takes, The Battle for Post-Crisis Europe. And we will be interested to hear what you will tell us about the topic of this panel against the background of your experience and your work. Thank you very much.
Thank you very much. It's a pleasure and honor to be here. I feel like the lone economist in a sea of lawyers. So a good point to start is actually the book that was just mentioned, because the subtitle Post-Crisis Europe was meant for the Eurozone crisis, because I started writing it after the Eurozone crisis. But then COVID happened. So I had to rethink the whole book and what it was saying about the future, which simply comes to underline the fact that we have and we will continue to go through a number of crises. The good thing is that there's a learning process underway. And I'll talk a little bit about that. And I would structure my comments around three themes: policies, institutions, and investments. So let me start with the first, policies. And the main question here is our economic policy stance and policy toolkit fit for the future, to stick with the title of the panel? And here, what we can say is the following. We have learned a lot from the Eurozone crisis, and we saw it very, very clearly in the COVID crisis. During the Eurozone crisis, we made horrible mistakes. We were late. We misinterpreted the crisis as being a fiscal crisis. It was actually a banking crisis. It took 2 years before we woke up to realize that, yes, indeed, without banking union, we would not be able to address the problem. And we improvised along the way. And often our improvisation was wrong. Overall, it managed to overcome the crisis at a huge economic and social costs in a number of countries, including my own. But we learned. And today we have an economic policy toolkit which is much more in tune with the times. We pulled out all the stops when the COVID crisis happened at a national level by allowing countries, by suspending the Stability and Growth Pact, allowing them to spend where they needed, where they absolutely needed to do to face the crisis, and at an EU level, by putting together the Next Generation EU, that I will say a few words in the end. But we are now at crunch time, because as the crisis is by no means over, but its economic impact is beginning to ebb, we have to now rethink some of those tools. And we are starting a very difficult debate about the future of the Stability and Growth Pact, a very difficult debate about debt breaks and what is the right level of debt. Let's remind ourselves, debt today is significantly higher than where it was when the Eurozone crisis hit, with different circumstances. We have a European Central Bank which has learned through the process. Luc mentioned the difference between the Eurozone and the COVID crisis. It took in the COVID crisis 2 months for the ECB to do what it took it 2 years to do during the Eurozone crisis. And not only that, but it is also adapting to the circumstances. It is integrating climate goals into its policy toolkit. It is thinking about the digital euro. So it is going very far beyond its primary mandate to seriously think, for the first time, I would argue, on the secondary mandate, which it does have within its treaty. But even there, there's huge disagreement among us in terms of how far it should go. And there are a number of countries, there are a number of courts that will be very vocal if they feel that the ECB goes beyond what they consider to be that mandate. So fasten your seatbelts, it's going to be a bumpy ride. We have a better toolkit, but by no means do we have, I think, the right toolkit for the circumstances. Turning to institutions, and I'm here also looking at my clock. Again, first of all, a sentence that may sort of not be particularly well taken in this room. Institutions are not sacrosanct. Institutions are time-specific and situation-specific. They often emerge, they always emerge, as some kind of a political compromise. And they're very suboptimal in most cases. So every time a crisis hits, we have to look at our institutions, see whether they're good for the task at hand, and if they're not, we have to come up with solutions. This is what Luke calls events politics, as opposed to rules politics, where we basically looked in the Eurozone crisis, did we have the right institutions to help one country not skid out of the euro and take with it perhaps the whole currency? Well, we did not, so we invented one. And then we invented the FSF and eventually the ESM. And there is this evolution in our toolkits, in our institutions, in our economic governance framework, and this is a good thing, and it will continue to happen, and we need to be open to that. There is, of course, always a balance to be kept. Obviously, you need to abide by the rules at hand, and I don't think I need to convince this room about that. At the same time, you also need to challenge to what extent they do the job for which they were designed originally. And then consensually, after a long discussion and political debate, decide how you go forward with that. And here, if I can say one word here, it is that I think that one of the elements that we have discovered as being sort of the missing child during the Eurozone crisis, and it became very clear in the response to the COVID crisis, was the question of political legitimacy in many of our institutions and the need for more accountability and democratic debate around what these institutions do. Last word on institutions, we're talking here about internal institutions, but actually the EU is the last bulwark in the defense of the multilateral system that allows us to face collective challenges. The US, which used to be its guarantor, certainly under the Trump administration, actually attempted to demolish the whole system, but there are some elements of that still remaining. So we need to think long and hard, and this is very important in our position in the world, how we will be able to buttress that multilateral system. Turning now to my third issue, which is the question of investments. The world has changed, and the world is changing, and I don't think that we need to be convinced that the climate crisis and the digital transition represent two incredible challenges, and that Europe is falling behind in both. The good thing is that we have realized this, and we have created a specific instrument which allows us not just to come out of the COVID crisis, but actually build back better, and that's the Next Generation EU and the national plans that come along it. And let's be clear, this is an instrument that is breaking a number of previous rules and is breaking a number of taboos in terms of the transfers, in terms of the common debt issuance for a one-off, and one can discuss that a lot, and also in terms of opening a discussion about new EU-owned resources. It is an incredible achievement which will rest and or fall on the ability of a few countries to actually implement their recovery and resilience plans in the way that we hope that they will. If they fail, I think the experiment will prove to those that were not particularly keen for it in the first place that this was not a good idea. If they succeed, it will open a whole new avenue for common actions. However, I think that there is a hole in the middle of all this. And this is that Next Generation EU and the recovery and resilience plans are a collection of national projects. What is missing here is European public goods. What is missing here is a bigger emphasis on the kind of goods that need to be produced and delivered and financed at a level that goes beyond the nation state. And we have proved with vaccines that this is an important element of that is binding us together. And we need to go much further in that. And it is a shame, it is an opportunity lost, that leaders did manage to get to the Next Generation EU, but treated everything as national projects. What do I bring home? As opposed to how do we collectively go forward? So these are my three kind of themes. And my last point here is that I think we've talked a lot and we keep talking about existentialist crisis for the EU in various. It's time to go beyond that. We have proved the resilience and an ability to adapt, which has disproved all the skeptics. During the Eurozone crisis, I kept telling people, no, the euro will not collapse because we have the political will to keep it together. And it's at the end of the day, it's a question of politics. It's a question of some people going around the room, staying until 4 in the morning, and deciding they will do whatever it takes to keep the project alive. And once that is done, then to start a very robust discussion with people with your background, expertise, to see how we can adapt that legal framework towards the political ends that we have decided collectively we want to pursue. Thanks very much.
Thank you very much, George. You have taken up the topic of the crisis, and you have told us that we have learned, the European Union has learned, it bungled a lot in the euro crisis, it has become better, but you also gave us a word of warning, a warning of the bumpy ride ahead, saying we have new instruments, but it's not enough, emphasizing that we need a multilateral approach, but we're not actually doing enough. But your final statement was again one of hope. We are resilient, this will survive. And here, perhaps we could continue with the discussion. If you have listened to our three panelists, then you could hear notes of perhaps criticism to a certain degree. But in all of the three cases, I believe the ultimate message was positive, at least when it comes to the resilience. Is it really so positive? You know, is it not so that we have also elements where really much more work needs to be done beyond what you just explained to us? Could you perhaps say something about this? To be fit for the future means also to look at what is still missing, the holes that you mentioned. Caroline?
I think some of the holes remain there. Like the problems of the euro crisis were never really solved. They were partially solved, and then there was another crisis taking all our attention. But it is coming back. But some things also change. One of the countries that was most fiercely against Eurobonds 10 years ago was Germany, and Germany is changing. I don't think we will see a revolutionary shift, but there's a new generation of economists. The old ones are retiring. The new ones have studied in America, in the United Kingdom. Lots of them at the Sorbonne as well. They know all their French counterparts. And so a pandemic hits, a totally different kind of crisis, reopening certain wounds. And they start attacking the old problem, which has become acute, and solve it for the time being again, because Next Generation is the Corona funds are temporary, as we all
keep emphasizing. Well, are they? We will see. I was talking to somebody who is involved in the selling of these Eurobonds, and he said we should actually issue much more, because investors are fighting to buy European debt. They've been waiting for this for decades, and now finally they have it. And they asked for 12 times more than could be sold. One other point there is we also need leaders sometimes. You mentioned, George, the European common good. And there's no need to be sentimental about it, but I was frankly very impressed by what Angela Merkel did. She's during the first lockdown in March or April last year, I think it was early April, she saw that Italy was really heavily affected, and she started to worry about the single market. And this is how she sold the idea not to lend money to Italy, but to give money to Italy. I mean, imagine this, in Germany. She went on television and she started to explain. She took a German company as an example and an Italian company operating on the single market. The German company, from a rich country that got a lot of government aid, Germany had enough money to keep its companies going during the lockdowns, competing with an Italian company that hadn't gotten anything. So the whole single market, she was explaining on primetime television, the whole single market would be out of balance because of that. And the single market is one of the bases, as we know, of the European Union. And if one company is advantaged and the other is disadvantaged, the whole thing will come to a halt very soon. And this is how she explained we have to give Italy money this time and not just lend it. And I was frankly impressed. And when you saw the vote, I mean, the Corona Fund was extremely popular in Germany, really popular. People understood this message. Second, it went for a vote in the Bundestag. And the Bundestag, gosh, in Brussels during the Euro crisis, how we feared the Bundestag. They passed it with an overwhelming majority. You need people to explain. To make the case, sometimes when we really need a European good, to make the case.
So Caroline emphasizes that there are holes, it is true, but there has also been a shift in attitudes and in ideas. You have said you wanted to respond.
Yeah, perhaps bring the discussion also to the international field, because I'm looking again at the title, What Role for Europe at Home and in the World? And as good Europeans, we have focused a lot on the home turf. Also, I think it's good to look at our, as Europeans, global situation, because there things are changing as well, and they are also coming your way, as, if I may say so, as EU lawyers and practitioners. Now, one much discussed word where you can see around which this is crystallized in the Brussels discussion, of course, is strategic autonomy. EU's wish to be less dependent, more autonomous. Now, this term has been treated with a lot of irony for years. It was discussed in circles of ministers of defense as a military term. It was seen as anti-NATO, anti-US, so better not talk about it. Now, what has happened now, also as a result of the pandemic in particular, is that, let's say, the semantic center of gravity of the word has shifted from the military domain to the economic security domain more widely. And there, the EU, of course, is changing its set of policies. And this already, in a way, has started, I would think, since 2016, more or less, 2016-17, which is not only the sad year of Brexit 16, but the Brexit vote at least, but also of the Trump election, and also of a series of very high-profile Chinese takeovers in German industry, German high-tech industry. As long as the Chinese were only buying ports in southern Europe, it didn't look such a serious problem. But once they started attacking, if I may say so, the most powerful country in the EU, the Brussels response came fast, for instance, in the field of foreign direct investment. And there are a lot of things happening in that field, industrial policies, where basically, and this also goes back to George's very important comment on the EU's role in the international order as the last bulwark of the multilateral institutions. But basically, you feel that the EU is ahead of a choice whether we should start treating the rest of the world differently than ourselves. I mean, the initial idea, of course, was we build an internal market, and we want that internal market over time to, in a way, encompass the whole world thanks to a multilateral trading system, etc. But as we now see that China and President Xi Jinping is officially theorizing this as a theory of dual circulation, but the same in the US, that these great economic blocs make a difference between their home markets and the way they deal in the international sphere. Of course, this also will ask the European Union, and at some point EU citizens will ask it also, if the institutions do not draw that conclusion themselves, to be less naive and perhaps not always give the benefit of the doubt to our contenders who want to destroy and compete with what we are doing. So there are real changes, but they really go, that's what I'm underlining this, to the heart of some of the, let's say, the DNA of EU economic law. And I suspect there will be interesting cases, institutional developments in the years ahead. But it shows, again, a capacity to adapt, even if slowly.
So thank you very much. We have turned to the global perspective, also from an economic, in an economic context, talking about the strategic autonomy in the field of economic and security domain. From a point of view of an economist, what issues do you see there for the European Union? George.
Okay, so I'll skip answering your question about being optimistic or pessimistic, and I will shift to that. I'm actually very glad that Luke opened the strategic autonomy discussion, because for far too long it was just closed within sort of defense and a geopolitical perspective. We now recognize that everything is geo-economic, and therefore we cannot be naive. And we've seen how international supply chains break. We've seen how difficult it is to bring them back. We've seen how you can be overly exposed in a time of crisis. So yes, of course, you need capacity and internal capacity across a number of sectors. And I think that it's a wake-up call to which most countries are rallying. And I do take the irony of the fact that nobody cared when the Chinese were buying ports in the south of Europe, because nobody else was interested at the time of the crisis to buy ports in the south of Europe, but they did. But when they move up north, we're beginning to realize. And here we have a special role to play, because we are between the US and China. We do not have the fear of the US that China is supplanting it as world power. We can play a more equilibrating role and a more intelligent role that is not a knee-jerk reaction. But at the same time, one that safeguards our basic interests. And this brings us to what it is that could make us more pessimistic, and that can make policymakers move forward rather than sort of keep working with the tools and institutions of the past. And I think the key to that is to look at the challenges ahead around climate and digital. There are revolutions happening. The private sector is taking a lead in climate. Financing institutions are taking a lead in climate. And they're not doing it out of the goodness of their heart. They're doing it because they realize that there's enormous profits to be made. And yet, as policymakers, in the first kind of bump on the road, where suddenly there is a problem with energy prices in Europe, we begin to second-guess ourselves and the transition, which is a terrible mistake. You need to use that to forge ahead. In digital, we are rightly so, and there's a lot here who will be discussing this issue, very much putting in we are the main sort of bloc in the world that wants to talk about privacy rights and who owns the data, and to have a distinct European imprint in this. This does not necessarily have to mean that we are laggards in a digital race. But if you look around at the moment, our companies are inexistent compared with what's happening in the rest of the world. So I am hoping for a more forward-looking approach that is trying to embrace what's happening and stop looking backwards and sort of second-guessing and being afraid of what we've built. What we've built is actually robust enough. We should have the confidence to build on it rather than second-guess it all the time.
So you have actually turned our view firmly towards the future, not just look back and ponder that, but go forward and try to play a more intelligent role, as you put it, in particular in two of the fields of the largest challenges that we have, climate and digital, which you mentioned already before in your introductory speech. What does it take? You know, we have to get our act together. At the European Union, with its 27 member states, which do not always share the same views even on those issues, pressing and clearly pressing as they are, can only move forward, as you said, in constant negotiations, difficult and so forth. So these are not things that can wait, ultimately, as the climate youth tells us on a weekly basis. One doesn't have the luxury of waiting for 20 years to develop something. So how do we deal with the fact that we have real problems that are pressing in terms of time, given the special nature of the European Union, which, as you said, is not a state but a union, and which for that reason has its special mechanisms that are cumbersome, ultimately resilient, yes, but cumbersome and difficult. How do we deal with this? How can we, in the framework of the multilateral cooperation, be strong and deal with these issues in view of the future? These will perhaps be my next question to you.
I think there's one thing we really need. Some people are saying we need treaty change for this, we need big institutional changes. I don't think we're going to get all these kind of revolutionary things. I think what we basically need is political will in the member states and of the member states. This. There are so many things that we can all do. The 27, but also wider. It's Europe. It's not the EU. I've lived in Switzerland. I've lived in Norway, and I've seen how Bern and Oslo are often copying decisions taken in Brussels, not because they have to, sometimes because they have to, but also because they want to copy them. They think if it's good for Europe, and the Norwegian Prime Minister even says this out loud, if it's good for the EU, it's good for us. And otherwise they're small, so they join in. But sometimes that kind of language is lacking in the member states themselves. They all have their own political dynamics, of course.
And there is a challenge, isn't it?
But you know, the funny thing is that even the populists that many people are so afraid of all the time because they're anti-European, and so, since Brexit, they're not so anti-European anymore. They have seen that it's not actually a very smart decision to leave the EU. So they have decided to do something else, to go to Brussels and to play the political game and try to change the EU from the inside.
Which might be worse, huh?
Which might be worse. Which changes the game. Yes, but somebody like Matteo Salvini, I mean, whatever you think of him, but he is part of a new generation who can play for local audiences, but also European audiences. In a way, it's what he says till now is not my kind of Europe. But what I hear from internal meetings with investors and so on, it's a whole different story that he tells. So I would like these people, or maybe not like, but let them come forward and take part in the political fights that we have in Brussels. It will make things clear, and it also will make Brussels, Europe, more sort of a grown-up democracy.
Thank you so much, ladies and gentlemen. I've received a point of order from the president of the FIDE that we should actually slowly conclude this panel. This means we will unfortunately not be able to do the question session we had announced.
So sad.
Yes, you'll have to do it. You have to do it over lunchtime. Caroline, will you agree that that was your closing speech? With one or two questions, she agrees. Okay. All right. But first, since this was I would say, a momentary final statement of Caroline, I would turn to George on this issue of what does it take? You know, we heard political will.
Very briefly. We should all be reading the Eurobarometer. It's actually fascinating. There's this growing gap between what the Europeans want and what policymakers are delivering. Europeans want more done at the European level. Clearly, across a number of policy areas, even in frugal countries, they want more done in the European level. And yet we're not delivering at the European level. And I think this reflects also generational change. And we see it clearly, we see it in climate. I mean, without the Greta effect, we wouldn't be where we are in climate. Let's be real here. So listening more to citizens and thinking at a level higher is the most difficult thing for politicians, but it is, I think, what we should be pushing them towards.
The necessary part. And Luc.
Well, let's go to the room.
Okay, then that means we have come to the point where 2 or 3 people can fight for the one question that can be asked. And I must say, I have a very light that I can't see much of the public over there, but I did see one hand in the front row. If a person with the microphone could come up. There we go. If you would kindly introduce yourself briefly and put your question.
Yes, my name is Takvoor Avedisian. I'm the president of the Central Tribunal, Appeals Tribunal of the Netherlands. I have a question for you, Mr. Papakonstantinou. Kalimera Sas. You were talking in essence about political will, whatever it takes. And you also say, like Frans Timmermans said, be open for reforms of the institutions. It's very important. What would you suggest for the institution of the European Court of Justice of the EU to change? I'm very curious about, because I believe in what you say, it's very inspiring. But what should be changed to keep up our strength for Europe?
I have a very quick and very easy question to that. Those of us that like politics, are kind of political junkies, have grown up watching every single decision of the Supreme Court in the US. I would love for Europeans to do the same thing with the ECJ. So more communication from the ECJ to European citizens and a more direct link to them, I think would be great, because if you ask people, more people know the US Supreme Court that they know specifically what the ECJ does, and I think part of the only good thing perhaps that is coming from the challenge to the primacy of European law here is that people are actually waking up to the fact that, okay, there is an issue here, and so let's think seriously about it. So I would urge, just like I would have urged the ECB to be more proactive in explaining, I would urge the ECJ, which I know is not always easy for lawyers to do, is to communicate more the essence of the importance of those decisions.
Thank you so much.
Only communication or also activistic?
I do not have the competence to be able to go into the substance of the decision.
Now the FIDE president has... The FIDE president has very graciously conceded us 1 or 2 questions, so I will take a second one. And she says that's the final one. Who is fighting to ask the second question? We did see a hand over here.
Can we take a woman?
Yes, if you could.
Krista, there's Laurens-Jan Brinkhorst.
Laurens-Jan Brinkhorst, which is very fit, as you know, because he actually, together with Professor Müller-Graf, is one of these really time-honored members of these conferences. So does he have a microphone? Here he is. Could we have a microphone right here? Second row. Laurens Jan, please, you have the floor.
Thank you, Madam Chairman. I was struck by the contrast between the speeches this morning by Leenaerts and Van der Woude, and also the President of the Supreme Court, and our panel. And I think it's because you are not lawyers and we are lawyers. But the most acute, and I think perhaps even pressing problem which we are facing of political will in a very short time, even before others, is the issue of supremacy of European law. I was here in '63 when we didn't have Van Gent and Loos yet, and we didn't have Costa Enal. But we agreed that on the political will, the fundamental issue of supremacy is now under very much threat. As Caroline, I appreciate Mrs. Merkel very much. She'd be fantastic. But she'd be very weak on the precise issue of what to do about the Poles and the Hungarians, and perhaps in the future the Slovenes and the Bulgarians, if we are challenging the supremacy of European law. Then all the other things are coming secondary. And I would like our our non-legal panel to react to that. What should happen in the short time? Because we are living a crisis, which I think is more fundamental even, and at short time than the crisis we are talking about.
You wish the entire panel to respond to that? Well. Who would like to respond?
Luc.
Well, I can say a few words, even if maybe I will not make myself very popular in the room. In the sense that I'm also, let's first state that clearly, I'm very worried also on the case and the attacks on the supremacy of EU law. But it seems to me that politically, right, the bigger problem is not that attack, but it is the context in which that attack is taking place, and which is what is happening in Poland, and which is the fact that Poland, just like Hungary, risks becoming an autocracy. And me, as a European citizen, that worries me more, in a way, that I will soon be a member of a club with autocracies as members, if I'm pushing a little bit the case for the sake of the argument, then this issue about EU supremacy, which, as we know, is very technical, we can have many seminars about it. And my worry is that for once, it's not always the case, but for once the Polish government has been very astutely in shifting the debate from what they're doing at home, which is killing the Constitution, to a fight with Brussels and Luxembourg, which only strengthens them, domestically at least, because they can pose as defenders of patriotism and national sovereignty, and which is very difficult for other EU leaders to deal with. They can pose as defenders of national sovereignty against Brussels or international interference. So the EU should take care to not lose sight of that more important political battle, and to not upset the chances of the Polish opposition. I hate to call them opposition, because they are not party political opposition. They are basically the defenders of the Constitution. To not upset the chances of the political opposition to win the next elections in Poland, which is where ultimately this risk has to be dealt with. And we can give all the moral support, and no doubt there needs to be more political and even financial pressure. And I also understand that the Commission cannot just pay out Corona recovery funds. At least I hope they won't. But to me, we should not, I repeat myself, lose sight of the most dangerous issue. Thank you.
Thank you very much for this, ladies and gentlemen. I would like to ask you to join me in thanking the members of our panel, Caroline de Gruyter, Luc van Middelaar, and George Papakonsinui, who have enlightened us, I think, with their special expertise and their non-legal view on important European issues. Thank you very much indeed for having been here. And with this, I pass back to the President of FIDE.